Hello, everyone. Welcome to Save News TV. I am your host, AZ Hubbard, and I want to thank you for allowing us into your homes today because you didn't have to. But anyway, today we have a shocker story. When I checked yesterday, um, the legal cases they hadn't uploaded it yet, so I'm just getting to it today. But baby, the Judge Stickman in the TD Jakes versus Duane Youngblood case is not playing with Tyrone Blackburn, who represents um, Duane Youngblood. And as you know from last video, that Duane Youngblood's attorney, Tyrone Blackburn, made a motion that he requested to no longer represent Duane Youngblood in the case, and he wanted off the case. It was a one sentence um, petition to the court. Well, baby, baby, we're going to get into this because the judge is not playing. And also remember the video before that when we were reading his response and pleading to the case, we were like, this doesn't sound like he's trying to either throw this case or he's been paid off or somebody else is filing this. Is he using chat gpt? Is he using AI? What is going on with this and this situation? But honey, Tyrone Blackburn wrote one sentence, but the judge wrote a 8-page finding, and he is not playing. So let's get into this. Also, the before we get into it, the playlist is going to be down in the comment section so you can get caught up on. We've been covering all of the pleadings, all of the court documents since the beginning of this trial. So if you want to catch up, so you can catch up to speed with all of us scholars over here on Save News TV, us Saveites. Um, but anyway, again, we don't have a dog in this fight. But one thing we love over here on Save News TV is a good legal writing, a good judge ruling, irrespective of what side it's on. Again, we don't have a dog in this fight. We are unbiased into who should win this case. But only thing I have to say, there was mastery in the writing that the judge just did. So let's get into this right here, right now. Okie dokie, we getting ready to get into this. Get your snacks, whatever you need, whatever you need, because this is a good one, baby. This is a good one. Okay. So this is the judge ruling and responding to Blackburn's request to get off the case. Okay. So the judge writes, defendant Duane Youngblood filed a notice of motion to dismiss, a supporting brief, and a reply brief requesting a dismissal of the plaintiff's Thomas Dexter Jakes complaint with prejudice. Youngblood is represented by attorney Tyrone A. Blackburn, the signator of the motion and brief. Blackburn is admitted pro hoc vice on behalf of Youngblood. While reviewing Blackburn's brief, the court became aware of the fact that they contain wholly fabricated quotations from case law, including fabrications, quotations from the court's own prior opinion, ECF number 40, in addition to including non existent quotations. The briefs repeatedly misrepresented case law. Okay, boom. Boom. Okay, boom. Boom. Now, normally, we're going to be reading and I'm going to be commenting, giving commentary in the midst of this. But the judge started out two barrels out at the beginning with it. First paragraph. Okay. He ain't waste no time getting into dude. This is what it's saying in essence. Dude, what is this? You want off the case, but you submitted the brief that doesn't even have the correct case law. Then you had the audacity to present the pleading to the court and you misrepresented even what I said in my own ruling. Baby, you better get up out of here. That's pretty much what the judge said in that paragraph, okay? So let's keep going. Jakes also noticed the issues with Youngblood's brief and addressed them in his brief opposing Youngblood's motion to dismiss. In his reply, Blackburn failed to offer any explanation for the deficiencies and fabrications in his briefs. Okay, plain English, save ice. Okay, he didn't try to explain why he's dropping these lies. Okay, okay. That's pretty much what the judge said. That's what he's saying. Okay. Instead, he brazenly attempts to mount a two quo quo defense, defense, asserting that the LexisNexis document analysis of plaintiff's own opposition brief reveals a pattern of misquotation, superficial citation, and invocation of authorities that are either inappropriate or do not support the propositions for each they are cited. The judge is eating him up, baby. The court thoroughly reviewed Jake's response brief, ECF 40, and did not find any fabricated quotations or misrepresentations, misrepresented case law. Okay, I'm a little tongue tied today. I better drink some coffee or something. Y'all got y'all coffee? Let me drink some coffee. Maybe my tongue will get untied as I read this brief. Only Youngblood, through attorney Blackburn, submitted a brief repellent with non existent quotations and repeated misrepresentations of actual case law. Even more outrageously, a review of Youngblood's brief demonstrates that it too includes fabricated quotes and misrepresents case law. In other words, when accused of a serious ethical violation, Attorney Blackburn chose to double down. The judge is not playing today, okay? He has no time for the foolishness and for the cray-cray, okay? This is very troubling. The court views Blackburn's conduct as a clear ethical violation of the highest order. Uh-oh. Uh-oh. Ethical violation? You all understand that ethical violation is paramount to disbarment. It could equal to disbarment, sanctions, and all kinds of stuff. Okay, let's get back in. On June 25th, 2025, Blackburn filed a withdrawal to appear, ECF number 52. Blackburn has legal and ethical duties under Federal Rule of Civil Procedure 11B and Pennsylvania Rule of Professional Conduct. And in attorney, as an officer of the court, has an overarching duty of candor to the court. Specifically, Rule 11B states that the attorney presenting a written motion to the court certifies that to the best of that person's knowledge, information, and belief, formed after an inquiry reasonable under circumstances, The claims, defenses, and other contentions are warranted by existing law or by a non frivolous argument for extending, modifying, or reversing existing law or for establishing new law. Now, remember, we talked about this when in the video before last, we talked about when that attorney signs, there is a legal obligation. There is that a standard that he is stamping. This is what I believe to be true. I have put my legal reputation on the line. The case law is correct. All of this, we talked about that again. The playlist is in the description so you can catch up. But also, we want to normally, I don't always read footnotes, but we're going to read the footnote here because it is critical of what the judge is saying. Even though Blackburn admitted to practicing law in New York State, he is subject to Pennsylvania rules of professional conduct since since he is admitted in the United States District Court of Western District of Pennsylvania. Pro Hawks Vice. See local rule. Admission or omission by an attorney admitted to practice before this court, individually or in concert with others, that violate the rules of professional conduct adopted by the court shall constitute misconduct and shall be grounds for discipline. Oh, uh oh, uh oh, uh oh, uh oh. The judge might discipline or sanction uh, Youngblood's attorney, Blackburn. The rules of professional conduct adopted by this court are the rules of professional conduct adopted by the Supreme Court of Pennsylvania. Whenever an attorney applies to be admitted or is admitted to this court for purposes of a particular proceeding, pro hoc vice, the attorney shall be deemed thereby to have conferred disciplinary jurisdiction upon this court for any alleged misconduct of the attorney arising in the courts of or in the preparation of such proceedings. Wow. Wow. And one thing I've seen and heard a couple of people comment on, this particular subject, but one thing they're not bringing out is because Blackburn is licensed in New York, but not Pennsylvania. He's only been granted permission to practice in Pennsylvania, pro hoc vice. That means that he had to get another law firm that's licensed in the state of Pennsylvania to come underneath their licenses. So now not only does he, the judge could really be petty and put the law firm that allowed him to practice pro hoc vice under their license could also be at peril. It depends on how the judge decides, he want to do this thing. If he really want to do the thing, do the thing. Not only could he get Blackburn, he could get the attorney's office that Blackburn is operating under, and even though they have nothing to do with this case. You see, because that was one of the problems initially when Blackburn was on the case in, trying to get in Pennsylvania because of the fact that he couldn't find an attorney's office that would allow him to practice or to come underneath their license pro hoc vice. Okay. But anyway, let's get back to more of this right here. Excuse me. Violation of Rule 11 may lead to sanctions. Baby, woo. Rule 11 sanctions are based on an objective standard of reasonableness under the circumstances. Bad faith is not required. Rule 11C1 provides that sanctions can be initiated either by a motion or on the court's initiative. So, in other words, what the judge is saying is either the it could be a motion coming from Jake's court for sanctions. Can you sanction this man? Or it could be the judge on initiative, the court's own initiative. And as we see now, it seems like the judge, Stickman, is initiating this right here, right now. Right here, right now. When acting on its own initiative, however, the district court should first enter an order describing the specific conduct that it believes will warrant sanctions and direct the person it seeks to sanction to show cause why a particular sanction should not be imposed. So, so the judge is saying, okay, this is the rule that I have to follow. This is the law that I got to follow in order to before I can imply some sanctions, and that is that I should first write an order, which I'm doing right now, describing specific conduct, which I'm doing right now, that believes with warrants sanctions and direct the person it seeks to sanction to show cause why a particular sanction should not be imposed, which I'm doing right now. So, oh, oh, Judge Stickman is not to be played with. He had time today. He had time today. Okay. A legal argument may be sanctioned as frivolous when it amounts to an abuse of adversary systems. Merely incorrect legal statements are not sanctionable under Rule 11B2. So, in other words, the judge saying, now just because you make a mistake, because everybody make a mistake, we all human. You could make a mistake and cite a wrong case. That's not sanctionable. Okay. But a lawyer shall not knowingly make a false statement of material fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to a tribunal by the lawyer. Pennsylvania Rule Professional Conduct 3.3a. The fact that Blackburn submitted fabricated quotations and misleading analysis of case law is plain to see from the face of its benefits. When reviewing Blackburn's briefs, the court was perplexed to see quotes attributed to the court's own prior opinion in this case, as well as other case law that was wholly fabricated. And now you can see clearly that the judge put in parentheses so it would be highlighted. Dude, not only did you fabricate information, you fabricated what I ruled on in this case right here. Like, you think I'm not even gonna know that what I said? Are you trying to play me, player? Is this what judge saying? Are you trying to play me, player? Okay. Are you trying to play me, player? Wow. The court was also troubled to find Blackburn repeatedly misrepresented case law to support his contentions. By way of example, the following italics portions of Blackburn's brief supporting the motion to dismiss represents a sampling of the fabricated quotes. Wow. Judge not only is bringing down the hammer, he is bringing the receipts. So the judge, he bringing his receipts. Number one, the court has already noted in its April 25th, 2025 memorandum opinion that plaintiff's complaint is repetitive and heavy on rhetoric with no factual details supporting the core elements of his claim. Number two, courts recognize that the threat of Protracted litigation could have an undue chilling effect on the exercise of First Amendment rights. Number three, the law requires a plaintiff to plead the exact words spoken or published and the context in which they were made. And then he put in parentheses, emphasis added. Now, in all of these, the judge is putting emphasis added, which in other words mean I got a problem with this, and I'm emphasizing this for you. Okay? Number four, the mere incantation of harm or reputable injury without identifying the defamatory words and the speaker is insufficient. Emphasis added. Okay? Emphasis added. The judge saying, I'm emphasizing this because I need you to understand and to know. Footnote. This is a long footnote. The judge is upset, okay? This fabricated quotation purportedly from the court's opinion, ECF 40, is repeated verbatim in Blackburn's brief at ECF number 46, paragraph 6, 43, paragraph 6. Not only does Blackburn attribute statements to the court that do not exist, but he also twists the court's prior opinion beyond recognition. For example, Blackburn claims that the court in ECF 40 stated one, that the complaint fails to identify with clarity the specific allegedly defamatory statements made by Youngblood, and two, that Jake's allegations rely on compulsory assertions and lack factual content. ECF 43, paragraph 6. The court made no such finding in its memorandum opinion. There is nothing in the court's opinion that could be reasonably construed as standing on such contentions. In that opinion, the court expressly refused to address the sufficiency of the complaint, stating, the court will dismiss Youngblood's motion because it relies on statutory provisions that are not applicable in this litigation. The court will not reframe Youngblood's argument to fit within Rule 12b-6 or Rule 56 framework. If Youngblood wishes to file a motion to dismiss based on Rule 12b-6 or Rule 56, he may do so provided that his filing complies with all applicable federal rules of civil procedure. Okay, this judge is hot. He's like, look, you ain't gonna be sitting here telling no stories on me. You're not gonna be lying on me. And here's the proof. This is what you think you twisted my words to say, but baby, this is what I actually said. The judge goes on to say, Blackburn later states in reference to the court's opinion, ECL 40, the court further noted that plaintiff's complaint fails to establish that Youngblood's statements were specifically of and concerning him. ECF 43, paragraph 13. Blackburn stated the court independently noted the deficiencies raised in this Rule 12b-6 motion on April 25th, 2025 memorandum opinion. The court observed the complaint's failure to allege specific defamatory statements, overuse of compulsory assertions, and the lack of factual content supporting falsities and malice. Once again, the court made no such statements in the opinion. The judge said, where you getting this from? I did not say that. Nor did it make any statements that could be remotely interpreted as standing for these propositions. This quote is repeated verbatim at ECF number 43, paragraph 6, page 6. Number 5. As a Pennsylvania Superior Court has held, absent of civil cause of action for a particular act, there can be no cause of action for civil conspiracy to commit that act. Emphasis added. Again, the judge is upset. I mean, he is putting his fire into his writings because everything that he is breaking down and bringing them receipts on, he is doing the emphasis added. The emphasis added. So in other words, I'm highlighting this. I'm highlighting this to make a very valid point. Number 6. The court noted that when the underlying tort collapses, there can be no cause of action for conspiracy. Emphasis added. Number 7. As the court held in Romano versus Young, without facts showing who agreed when they agreed and to what end a conspiracy cannot survive. Again, emphasis added. Number 8. Group pleadings, in particular, improper in civil conspiracy claims where individuals' conduct and malicious intent must be alleged, as the court stated in Duffy versus Lawyers. Plaintiffs must allege facts supporting the inference that each defendant acted with specific malice and in furtherance of the shared unlawful purpose. Absence this showing, a conspiracy fails, claim fails. Emphasis added. Excuse me. The judge got the emphasis added. He is on the emphasis added kick. Even after being accused of making false representations in his initial brief, Blackburn's reply brazenly contained misrepresentations of law and particularly fabricated quotations. The initial portions of the quotations from Blackburn's brief below do not exist in case law. It do not exist. It's nowhere. These quotes represent a sampling. Now, this is a sampling, a sampling of the partially fabricated quotes contained in his reply brief, bullet points. I mean, he said, the judge said, this is just a sampling. So if he's only sampling, you know there's more. Whether a communication is capable of defamatory meaning is a threshold question of law for the court. And he quoted some things. Again, the judge is adding emphasis. Even where the words themselves seem mild, Pennsylvania courts have shown a willingness to interpret relatively mild statements as being capable of a defamatory meaning, but only if the innuendo must be warranted, justified, and supported by the publication. Again, we know the judge is emphasis added. Critically, the plaintiff must specifically identify the context of the defamatory statement. Vague accusations or general assertions of wrongdoing are not enough. The Supreme Court has made clear failure to investigate without more does not establish actual malice unless the speaker, in fact, entertained serious doubts as to the truth of the publication. The Third Circuit is in accord. Failure to investigate without more does not demonstrate actual malice unless the plaintiff pleads facts showing the defendant purposely avoided the truth. Emphasis added. Okay, so the judge is coming strong. The judge is coming strong. He is got that gavel, boom, boom, boom. Okay. These quotations are merely representative of the fabricated statements in Blackburn's brief. There are additional fabricated quotations that the court does not enumerate in this order. So, in other words, there were so many. I'm not even going to write them all out in this order. Okay? I'm just showing you a few of these that don't exist. In addition to including non-existent quotations in his brief, Blackburn also cited cases for a proposition that they do not represent. The court will not recite every time Blackburn's misconstrued a case in his briefs as it believes the above quotation represents the most serious and alarming issues with the documents. So, in other words, Judge said there's just so many of these things. I'm not even going to waste my time with all of these mistakes and these errors of non-existent cases and non-existent quotes, but I'm going to give to you the most egregious ones, and I've listed them above. Okay. Attorneys are permitted to make creative case comparisons and may even stretch existing case law to support their arguments. So the judge said, attorneys got a little leadway here and there sometimes and everything. But judge says, nevertheless, advocacy is confined to Rule 11B and PARPC 3.3. Attorneys have a duty of candor to the court. They must make reasonable inquiries under the circumstances to ensure their legal contentions are warranted by existing law. Attorneys may not, hear me now, attorneys may not fabricate non existent quotations from case law or the court's opinion and may not cite cases for legal propositions for which they do not stand or even discussed. The court presumes that Youngblood's briefs were constructed by generative artificial intelligence used by Blackburn. Oh, the judge just said, Blackburn, the court believes that you use AI. We believe you cheated on this, that you use AI to write these briefs. Rather than an effort by Blackburn to personally construct false and misleading briefs. So this is what this judge says. The court presumes he's giving a benefit of the doubt. I'd rather believe that you use AI than for you to believe that you didn't take time to write this case now. So let's read that part again because it's worthy. The court presumes that Youngblood's briefs were constructed by generative artificial intelligence used by Blackburn rather than an effort by Blackburn to personally construct false and misleading briefs. It does not matter. Attorneys have an ethical obligation under Rule 11 and their state respective professional canons to review every document submitted to the court under their name and signature to ensure accuracy, candor, and overall compliance with ethical obligations. Remember, we talked about this, Savites and scholarettes. Yes, scholars and scholarettes. Yes, we talked about this. This duty is you cannot delegate, non-delegate. An attorney must who signs and files a brief offered by a non-lawyer under such as a paralegal, secretary, or intern is personally responsible for all it contains. And the same applies to artificial intelligence. So, in other words, whether you used AI, whether you have a paralegal, secretary, intern, or whatever you do. Whoever, when you put your signature on that, you are responsible for the contents thereof. In other words, Youngblood could not outsource his obligations to the court as his client to a third party, including artificial so-called quote intelligence, unquote, whoever or whatever. Whoa, this judge is getting down with the get down. Whoever or whatever drafted the brief signed and filed by Blackburn, it is clear that he, at the very best, acted with culpable negligence of his professional obligation. The alternative is that he acted in conscious effort to deceive and mislead the court. At this point, in light of Blackburn's continuing offenses in his reply brief, the court is inclined to believe the latter. So, in other words, whoa, baby, whoa, whoa, baby, whoa. So, the court is inclined to believe the latter, which is that he is he acted with culpable negligence of his professional obligation. Now, that, baby, is a mouthful right there. So the judge is getting ready to slam that gavel down on Blackburn. Yes, he's getting ready to slam that gavel down on him. Okay, because the judge is really getting ready to lay this hammer down now. So, are you ready? Here it comes. Here comes not just the gavel, but the sledgehammer. Oh my gosh. And now, this 26th day of June 2025, it is hereby ordered that the defendants, Duane's Youngblood motion to dismiss according to Rule 12b-6, ECF number 43, and reply memorandum of the law is further support of defendant Duane's Youngblood motion to dismiss are stricken from the record. Okay. Stricken from the record. Did you see that? Stricken from the record. Oh, my word. In accordance to the Federal Rule of Civil Procedure 12A4A, Youngblood must answer Jake's complaint on or before July 11th, 2025. It is further ordered that Blackburn is ordered to show cause not to exceed 15 pages by July 18th, 2025, as to why his statements in ECF numbers 43 and 46 have not violated Rule 11B and PA RPC 3.3. Specifically, Blackburn is directed. Wait a minute. I got to get this thing. Woo! Blackburn is directed to show cause as to the fabricated quotations and blatant misrepresentation of case law and the court's opinion in his briefs. Wow. 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 Possible sanctions include, but not limited to, monetary sanctions. Wow. Including attorney fees related to litigations of the motions revocated of Blackburn's pro hoc vice status. Whoa. And any other sanctions deemed appropriate by the court. Oh my God. Now I'm gonna read the footnote on page 7. It says the court is so alarmed by the deficiencies and potential rule violations in Blackburn's filing that it will not consider any subsequent arguments raised by Youngblood's motion to dismiss or the reply. Wow. Wow. I don't think I've ever seen anything like this. Have you all? This is a gross misrepresentation. It is finally ordered. The judge is coming for his throat. It is finally ordered that a show cause hearing will be held on July 24th, 2025 at 1:30 p.m. in courtroom 8B for Blackburn to show cause as to why sanctions should not be issued relative to potential violation of Rule 11B. Whoa. Ho. Is the judge Stickman going to take his license? Make him pay? If Jakes plans to seek attorney fees in relation to the litigation surrounding the motion to dismiss ECF number 42, Jakes and his counsel must attend the hearing. Otherwise, all parties and counsel are welcome to attend to show cause hearing, but only Blackburn attendance is required. So, in other words, what the judge is saying, all right, Jakes, if you want to get your money back for the attorney fees, that the time they spent answering these two briefs that Blackburn filed, you need to be in court, because chances are I'm going to give you your money. Okay? I'm going to give you your money for the time that they wasted replying to this craziness that Blackburn filed. That's what the judge is basically saying. Blackburn shall supply a copy of this order to his client Youngblood and file a notice of compliance on the court's docket. After doing so, Blackburn's attempt to withdraw from counsel of this action does not insulate him from the repercussions of his actions. So, in other words, dude, even if I allow you off this case, which has yet to be determined, it is not going to exempt you from the repercussions I'm getting ready to slam down upon that head if you cannot show cause why I should not. Okay? On July 24th at 2025 at 1:30 p.m. in courtroom 8B. If you can't show cause why I should not sanction you and throw the book at you, we're gonna have some problems. You're gonna have some problems. And you, just because you want off the case, is not gonna excuse you from this. And the judge finishes off with his pending withdrawal appearance will remain under advisement until the resolution to show cause hearing. So, in other words, you still on this case, bud. You still on this case, buddy. You are still on this case. And the judge is not playing with you. He is not playing. He came, he had time today, and he made time. And he is not playing. All I'm gonna say is, baby, I would not want to be Tyrone Blackburn. Tyrone Blackburn is getting ready to be in for a world of hurt. A world of hurt. If he does not arise to the occasion of the show cause case on July 14th, I mean 24th, on July 24th at 1:30 p.m. Okay. I need you all to get in these comments and tell me what you think, because like I said, if you go back to the couple of videos, you will see where I was talking about, we were talking about we couldn't understand that his pleading in this situation, because it just seemed like he was either trying to throw the case, or what was he doing? It made no sense. I mean, Black Youngblood's story had totally changed from the house to the car, and him misquoting things. Even we picked it up, and we are the savets, the scholars and the scholarettes over here, and we're not licensed attorneys or anything like that, but we picked it up. And if we picked it up, the judge picked it up. He was like, "No, boo, this is not going to fly. Not today in my courtroom." And I believe that um, Tyrone Blackburn is in a world of trouble. According to this judge, he can be sanctioned. Um, what did the judge say? He said, possible sanctions include, but not limited to, monetary sanctions, including attorney fees related to the litigation of the motions at issue, revocation of Blackburn's pro hoc vice status. So, in other words, we're going to pull you up out of this state. Them license, they're going to be gone up out of this state. And any other sanctions deemed appropriate by this court. The judge is not playing. The judge is not playing. Here come the judge. The judge came and he went. Okay. The judge is not playing. He had time today. So anyway, I'm just gonna say it. We don't have no dog in this fight. We are unbiased. But one thing we can say is that the judge, he don't let the judge has been fair all along. He doesn't let Jake's team get by with anything and everything, and he's not letting Youngblood's team get by with any and everything. I don't know whether Youngblood have another attorney lined up, but until, just like the judge says, until this is resolved on July 24th, 2025, Blackburn is still the official attorney of record, you know. And according to this, um, Youngblood has to answer Jake's by July 11th. So that means that Blackburn is going to have to write another brief to reply, because the judge has stricken, not just stricken, he's stricken it from the record. In other words, I'm throwing it all the way out. All the way out. It's like it never existed. It's like you never filed it with this court. Okay. And then, you know, then, after the 11th, by the time Youngblood have to answer to Jake's, Blackburn then has to show cause not to exceed 15 pages by July 18th, 2025, as to why his statements have not violated the rules, and to specifically is directed to show thus cause as to the fabrication, quotations, and blatant, not just misrepresentation, blatant misrepresentation of case law and the court's opinions in his briefs, you know. And then after he filed that no more than 15 pages, and with the stipulations that the judge has said that could happen to him, Then he's ordered to come before the judge on July 24th, 2025 at 1:30 p.m. in courtroom 8B. Okay. If we got some mixologists as far as music is concerned and some rappers, I think that would be a good song. July 24th, 2025, 1:30 p.m. courtroom 8B. You know, I'm not a singer. You know, it's not my thing. And I'm definitely not a rapper. But music is not my strength. Okay. I need to stay in my lane. But anyway, everybody, listen, get down in those comments. Make sure you like, share, and subscribe. And let me know what you think of this case. You know, we're going to keep on it. We're going to keep on it. Make sure that you follow, go down in the comment section where there is a link to the playlist so you can get caught up on the case if you've missed any of the what's been going on. But there's been a lot going on and we have a playlist of it. So anyway, I appreciate all of each and every one of you. And I want to thank you for allowing us into your homes. We read these cases unbiased. I'm giving commentary in between. Sometimes I wait to the end, but this was just such writing from Judge Stickman that I could not wait to the end. I needed to elaborate in between and give commentary in between. That's why I show you the document on the screen so you know when I'm elaborating and giving my personal commentary and when the judge is speaking or when the document itself is speaking. But anyway, I thank you all so much again for allowing me into your homes. Please like, share, and subscribe. You all have a very blessed day. Stay tuned because we have another video coming up. You all have a very blessed day. Bye.
Getting bored? Want to enjoy some relaxing music? Do you need to get updated with all the latest news but don't have enough time to watch TV for hours? Or do you need to get your praise and worship on? We have your solution to your problem. SAVEDnewsRadio.com got everything you need. Listen to SAVEDnewsRadio.com, filled with praise and worship 24/7, everywhere, in your home, laptop, or tablet, on your phone, in your car, and on Alexa. Install the Save News Radio skill on Alexa and then just say, Alexa, launch Save News Radio. The beautiful, uplifting sounds of praise and worship music, ministries, news, and more. SaveNewsRadio.com, created to glorify God and edify the body of Christ.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn, his love we adore. Each melody a testimony, hearts reborn. In every verse a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify with every note we sing. In harmony let freedom's bell ring. Rejoice and lift your voice, let the sound of praise deploy. Marching to his beat we go, face the seed we're here to sow, standing strong through trials.